If you're paying child support to the other parent, there's some reasons why you might want to seek a modification. I've got the top 5 here. Number 1, you've got a decrease in your income. Either you've lost your job, you've been laid off, or you've just been reduced to fewer hours and you're making less money. That's the number 1 reason. Number 2, the child has aged out, turned 18 in most states, 21 in some other states, graduated from high school or college in some cases. That's a reason. That's the number 2 reason to go in. The court doesn't automatically do that. They don't keep up with how old your child is. The third reason is the child has moved in with you and is no longer living with the other parent. Now you've got that added financial burden. So you need to go to court and modify it and get the other parent to pay you child support. The other one is the child is no longer in daycare and you don't have those daycare expenses anymore. And finally, there's an increase in the other parent's income. And in those states that take into consideration both parents' income, you need to go to court and get your child support decreased. We're going to go into detail on each one of these areas in upcoming videos, so stay tuned. Michael was 3 years old when his parents separated. They agreed on a week-on, week-off schedule. Dad would have 1 week, Mom would have 1 week. When Dad would bring Michael home from his parenting time for the start of Mom's parenting time, Mom would find a bruise, a cut, a scrape, a knot on the head, something going on with Michael that would cause her concern. So what did she do? Well, she called the Department of Children's Services and reported that Michael had been abused at his dad's house. Every time, DCS would have to send an investigator over to Dad's house to do a full investigation to determine whether or not there was abuse. And every single time they found no abuse. Every single allegation was unfounded by DCS. Well, this went on for a year and a half, 17 allegations. So Dad took Mom back to court with a petition to modify, based in part upon all of those allegations that Mom was making that were unfounded. Mom admitted to it in court. Dad ended up getting custody of Michael, and Mom had weekend parenting time with an admonition not to make unfounded allegations of abuse against Dad to DCS. A couple of years ago, I had a child support case where we needed to go back and calculate what somebody's child support should have been going back 10 years. In order to do that, we needed to know what each party had made during the preceding 10 years for each year. Well, that's hard to do because most people don't keep their tax returns for more than 5 or 7 years, and certainly not their W-2s for any length of time. So the best way to do it, and what we found out, is to get on My Social Security, create an account, and download your earnings history. It's great to keep up with that anyway, to know what your Social Security benefits are going to be when you retire. But it also tells you what you've made each year. Here's a copy of one that they have, an example on the Social Security's website. And it shows each year what the person has made. That's how we did it. We went back and calculated the average amount that that person had made over the preceding 10 years, and that's how we set child support. Keep up with that. It's a good thing to know, and it's a good thing to keep up with. Why not 50-50 parenting time in every single case? Why is it so difficult for courts and society in general to accept 50-50 parenting time? Well, about 10 years ago in the state of Tennessee, the legislature was toying with an idea about making 50-50 parenting time the default position for all cases involving children where custody and visitation was at issue. The legislature would have passed that law, and it would have said 50-50 parenting time in every case, unless it can be shown that 50-50 parenting time is not in the best interest of the children. So instead of passing that law, what the Tennessee legislature did was pass a law that said that each parent should be given the maximum time possible with the children, consistent with the best interest of the children. And so it kind of puts the burden on the party wanting 50-50 parenting time to prove that that would be in the best interest instead of the other way around. Roderick and Roseanne got married right out of high school. She was kind of a go-getter. She went to college, got her 4-year degree. He, on the other hand, didn't amount to a whole lot. He had a few jobs on and off, but he developed a drinking problem, a gambling problem. He was an athlete in high school, but that didn't translate well into adulthood. He gained a bunch of weight. He was pretty much lazy. Well, after she finished college, she left. They split up, but they didn't get divorced. About 15 years later, they'd been married now for almost 20 years, she decided she was going to file for divorce. She was shocked to learn from her lawyer that he was going to be entitled to half of her 401k that she had been saving up. It was now worth in excess of $500,000. She was shocked. Folks, remember, there's a clock that starts running when you get married, and that clock doesn't stop running until you get divorced, until the judge bangs that gavel and says you're divorced, and anything you acquire during that time period is going to be marital property subject to division. You may not be able to testify about the abuse your child is suffering at the hands of the other parent. And here's what I mean. If a child comes back from visitation with the other parent and starts telling you stories about things that are going on and it causes you concern and you think your child may be in danger, well, there are a number of people you can call, but one of those people needs to be a child psychologist. And here's why. When you get up on the stand to testify about the things that your child has told you that cause you concern, you're going to get hit with a hearsay objection, and the judge is likely going to sustain that objection because you can't testify as to what somebody else told you, even a child, except in very limited circumstances. But who can testify about that is a child psychologist. If the child went to the child psychologist and told that child psychologist those things, and the child psychologist used those statements to form a diagnosis, then those statements are admissible in evidence. And that's how you get around the hearsay rule. Do you have an internet business? Many of you do. If you do, listen up. This is a story about Tamara and William. They got married at a young age. She was 19, he was 21. He had a decent job at the time. He was working at a local warehouse. Tamara wasn't working at all when they got married, but soon after they got married, she started an online-based business. Now, her business consisted of her showing different makeup and beauty tips. I don't understand it, but apparently that's a thing. Apparently it can make money. It started out as just a hobby, but soon after that, it started making money. And by the time they filed for divorce, about 7 years later, her little hobby was making over $200,000 a year, far more than what William was making. Now, at first, William wasn't interested in the little hobby and thought it was ridiculous. That is, until he spoke to his divorce attorney and he realized it's a legitimate business, it's worth hundreds of thousands of dollars, and it's marital property, meaning he has an interest in that business even though he didn't start it and doesn't have anything to do with it. The problem is, how do you value such a business? Well, believe it or not, there are actually companies out there that will look at the business and give it a value. They will value internet business. The issue with this business was whether the business had a value apart from Tamara. In other words, if the business was sold and she was no longer involved in the business, would it still make money? Or was she such an integral part of that business that you couldn't separate the business from her? Well, as it turned out, the business had an estimated value after the valuator analyzed it of about $450,000. They finally agreed that William would keep his entire 401k, which at the time was worth about $275,000. She would keep the business, but she would pay William $75,000 as his share of the business at the rate of $2,500 a month for 3 years. Valuating these businesses can be tricky. Those businesses can be somewhat speculative. They depend on the platform that you're on, the reputation that you have, the whims of your viewers. The valuator will look at things like revenue stream, inventory, if you have inventory, debt, intellectual property rights that you might have, operating cost. Then there are additional intangible assets that they're going to look at, such as the time spent building the business, the effort required to maintain the relationships of the customers you have. All those things will be taken into consideration. But if you have a business, an internet business, and you're married and you're contemplating divorce, keep in mind that that business is probably worth some money.